Ontario is a great place, isn't it? Or is it? Clean towns and cities, beautiful countrysides, deep blue skies as far and as high as the eye can see. And fresh, clean water are everyone's idea of how things should be. Yes, it is a great place, but it could be better. The good news is that we're going to do everything we can to make life in Ontario better than ever, with the help of Ontario's new Environmental Bill of Rights. The Environmental Bill of Rights. The name may sound a bit imposing, but its goals are about as grassroots as you can get. It's all about protecting the environment and how citizens of Ontario can right environmental wrongs. It's also about the steps that can be taken to assure that potentially damaging practices never get started in the first place. The Environmental Bill of Rights is the result of over 3 years of careful planning and refinement. The bill is founded on the democratic principle that everyone has the right to participate in decisions which will affect their environment. It gives every citizen of Ontario the unprecedented right to have their environmental concerns heard and acted upon at the responsible decision-making provincial government levels. One very important factor about the bill that assures its fairness and effectiveness is that it was developed to a very large degree by people just like you. Ontario's Environmental Bill of Rights creates what we believe is an environmentally positive situation for everyone. It opens up the provincial government's environmental decision-making process to much greater public scrutiny. It gives business a uniformly fair process by which to plan for the future and to obtain environmental approvals. It also provides the information and access needed to participate in government's all-important decision-making processes. And above all else, the Environmental Bill of Rights gives everyone the opportunity to protect the environment to a greater degree than ever before. Having said all that, let's take a closer look at how it works. To begin with, compliance with the bill is monitored by an appointed officer called the Environmental Commissioner. Let's look at this role for a moment. The Commissioner wears a number of hats. He or she is a skilled administrator, an information officer, a watchdog, a spokesperson, a guardian of the individual's environmental rights, and it is the Commissioner's office that is ultimately responsible to the legislature for the fair and efficient evaluation of the bill's effectiveness. Let's look now at an overview of some of the procedures that make the bill work. To begin with, 14 separate provincial government ministries fall under the jurisdiction of the bill. Each ministry will develop an individual statement of environmental values, stating how it will take the environment into account in its decision-making. One of the most unique aspects of the bill, and the one that brings the public into the picture, is the Environmental Registry. The registry will be the main source of information about the statement of environmental values, new legislation, approvals, permits, or policies being proposed by each ministry. Access to the Environmental Registry can be accomplished by modem from a home computer or through a public computer station. Many will be located at local public libraries, college and university libraries, and at government access points, such as Queen's Park. Let's suppose that a ministry proposes a new policy or legislation which people learn about through the Environmental Registry, and someone believes that it has environmental shortcomings and they want to do something about it. During the specified time period on the registry, you may submit relevant comments to the responsible ministry. The ministry must consider these comments in making a decision and place notice of the decision on the registry. Another part of the Environmental Bill of Rights where the public can get involved is the request for review. 2 Ontario residents make a written request for review to the Environmental Commissioner's Office. Within a 10-day period, the Commissioner's Office will forward the request to the minister responsible. The minister is duty-bound to confirm the receipt of the request. If the minister determines that a review is not warranted, both those requesting the review and the Commissioner's Office will be advised of this decision and the reasons for it. If a review is deemed necessary, the minister must advise the 2 citizens and the Commissioner's Office of the outcome of that review. A request for an investigation may be initiated when someone believes there is an environmentally unsound practice which is against the law. This request is handled in the same manner as the request for review. When harm is occurring to a public resource and someone isn't satisfied with the outcome of the request for investigation, they still have recourse to the courts as another forum in which concerns can be heard and assessed. The available outcomes from the courts are an injunction to stop the damage or the development of a restoration plan. There can be no financial gain for the plaintiff. If the citizens are concerned about reprisals from the investigation request because the offending party is their employer, there's nothing to worry about. When someone participates in the Environmental Bill of Rights, they are protected by safeguards built into the bill to assure strict confidentiality and offer protection from employer reprisal.
Excuse me?
Yes?
Could I review a few things with you?
Sure.
Let's say I learn about an application for an approval by a company on the environmental registry, and I think there might be something environmentally wrong with it. I really just want to express my concerns. What can I do?
That's a good question. If you have any concerns, you can write the appropriate ministry with your comments. The ministry will take them into consideration in making any decision. Furthermore, the ministry must advise you of their decision by placing notice of it on the registry.
Okay, but what if I don't like the ministry's decision and feel that environmental harm may occur?
When the company has an automatic right to appeal a ministry decision, you now have the right to seek what's called leave to appeal. If you can demonstrate that the government's decision was unreasonable and harm to the environment could result.
What happens if I don't agree with a past decision or policy in a ministry? Can I ask for a review of the issue?
Yes, you can, with the support of one other resident by writing a letter to the Environmental Commissioner's office.
What if I know that someone is breaking an existing law? Can I do anything about that?
You sure can. You and another resident can request an investigation by making a sworn statement to the Environmental Commissioner's office. It'll be forwarded to the appropriate minister. If the minister concerned carries out an investigation, you'll be advised of the results. If an investigation is not deemed necessary, you'll also be advised of the reason. And if you're not satisfied with the outcome of the investigation, you can access the courts as a last resort. It's important to note that no financial gain for the plaintiff can be achieved from any court decision handed down to protect the environment. Government must be given an opportunity to conduct an investigation before accessing the courts unless imminent harm could result to the environment.
Okay, suppose I know that my employer is dumping toxic chemicals down the drain. If I want to keep my job, I better keep quiet, right?
Wrong. As we discussed, you and another person can request an investigation through the Environmental Commissioner's office. All names and personal information are strictly confidential, and the bill provides protection against employer reprisal in case your employer somehow discovers that you initiated the investigation.
Let's say an industry is polluting a lakeshore and the fish are dying. As a result, I lose my job in the fish processing plant. Can I sue?
Yes, you can. Any person can sue when they suffer direct economic or personal loss as a result of a public nuisance causing environmental harm. Prior to the Environmental Bill of Rights, there was no opportunity to actively participate in the decision-making process in a consistent fashion. Ontario's long-term health and prosperity depend on the strength of our commitment to protecting and, where necessary, restoring the environment to good health. Beyond the benefits to our personal health that clean air and water can bring, a clean environment creates real incentives for investment in Ontario, bringing with it dynamic economic growth and opportunities for job creation. It is our sincere hope that the bill becomes a landmark for the preservation of the environment and a giant step towards solid economic strength in Ontario. We hope that this brief presentation has given you a general perspective of the scope of the bill. More importantly, we hope that it has instilled in you the spirit of the bill and its importance today and for generations to come. No matter how you look at it, Ontario is a great place to be, and with the Environmental Bill of Rights working for every citizen, it can only get better. Let's all be a part of it.